may change you, but you might need to.
Well, the problem is no one can see that really.
Are we all set? Okay. 19 CF 2917, State of Wisconsin versus Keith Kenyon, appearances.
Steve appears by Aaron Marshall. Good morning.
Good morning, Your Honor. Beauty, Williams, and Skilling, appearing by Attorney Jerome Beauty, with Mr. Kenyon, who is in court, with interpreters.
Primary interpreter, and Wallman, WOHLMUTH, and my colleague.
Jan Walden, JANN, MAULDIN.
And I'll swear both of you in. You swear or affirm that you will interpret truly, accurately, completely, and impartially, in accordance with the standards prescribed by law, the Code of Ethics for Court Interpreters, and Wisconsin Guidelines for Court Interpreting?
I do.
Thank you.
Did you pull it now?
Yeah, we're good.
All right, we're going to continue with the hearing related to the defense witness. There was testimony taken. The defense witness is appearing by video, by Zoom, as she's out of state. Everyone else is in person. And we started testimony, and I think defense counsel either finished or was largely finished with his examination, and I think the state had started theirs, or was about to start. So we'll pick up from there, and I'll let Ms. Carson start in a minute. Before that, my clerk asked that the defense and I make a record as to the interpreters. Obviously, I've had interpreter cases before, and I have other cases that involve interpreters currently. I'll admit I don't completely understand the difference between SL interpreters. It's my understanding that the two ladies that are present today are both ASL interpreters. Is that correct? They both indicated that that is correct. And I think that's what we had at the last hearing a number of weeks ago. So I'll just ask Mr. Buting and his client if they're okay with proceeding today with the two interpreters we have present. If we get to a trial at some point in time in the future, we can obviously address that again before the trial, as there's some logistical needs related to that. But for today, Mr. Buting.
Judge, for today, I think we're okay. I would certainly trial, I think we're going to need certified that for the CDI. And how we count a counsel table for the CTI. Well, so that I can confident communications with my client. But for today's purposes, I don't anticipate need to communicate with him in the middle of testimony that would require counsel interpreter, counsel table interpreter. So I think for purposes of this hearing, we're okay, but certainly for trial.
And Mr. Kenyon, I'll just ask you, are you comfortable proceeding today with the two interpreters we have present?
Yes, I am.
And if, as the case, strike that, first of all, we'll take a break in about an hour. If we're done in an hour, fine. Otherwise, we'll take a break at 11 o'clock for two reasons. A, to give the interpreters a break, and also so I can call another case that'll take 5 or 10 minutes. But if at some point in time, Mr. Kenyon, it becomes a problem and you're not able to understand the interpreters, or you're having any trouble whatsoever, let your attorney know or let me know, okay? Fine. With that, I think we're ready to proceed. We'll swear in the witness. Doctor, can you hear us?
I can hear you, Your Honor, but I can't hear the attorneys.
All right, I'll make sure the interpreters speak up, use their microphones, and I'll turn up their mics as well, best as I can.
I do.
State your name, please.
Did you ask a question?
Can you just state your name, doctor, and spell your first and last name?
Dr. Jacqueline Bashkoff, Jacqueline Bashkoff, Bashkoff, as in Frank.
As we're proceeding, I just turned up the microphones, and not everyone's born as loud as I am, so I'll just ask Ms. Carson and Mr. Buting to use their microphones, please.
Yes.
If the state's ready, you can proceed, Ms. Carson.
Your Honor, there is one issue before I begin my cross-examination of the defense witness. When she testified at the last hearing, she mentioned. Her report lists studies by researcher, and I shouldn't say list studies because it just lists researchers and years. She then testified at the last hearing by researcher last name as to different topics. After the last hearing, I asked Mr. Buting for copies of those studies so that, because I think I'm entitled to them, his response to me was that they're easily available and I should look for them. It is not my obligation to Google and guess which studies the defense expert is referring to. Therefore, I'm asking that this court order that he turn over the studies that she references in her report and that she referenced in her last testimony to the state. If the tides were turned, and there is case law from the Supreme Court and recent case law that it is the state's obligation to turn over things that are readily available to defense counsel, such as criminal records, which are available on CCAP, and no one has to Google and guess, but I have to turn them over, such as 911 calls or other information that is readily available with Freedom of Information request, but I have to turn them over. It is not fair in this case to tell the state to Google and guess which studies the defense expert.
Can it slow down a bit? Go ahead.
So, as I was saying, it is not fair for the defense to say, go ahead and Google and guess which study she's referring to. I'm asking that the court order that she turn them over to me.
I'll hear from Mr. Buting, and at some point, we can clarify what reports or studies we're referring to specifically, but Mr. Buting.
If we can just maybe focus on what we're doing here today, this is a valid period. Tried the studies, how to use her report. Her report is essentially saying that these are the Wisconsin forensic interview guidelines. And in her opinion, her references to other studies are the underlying science, I guess, that has resulted in those and other forensic guideline protocols that are used throughout the country. So the state of Wisconsin has already found that the underlying studies supporting the need to question a child in a particular way have been established as valid science. And, per se, because they have adopted these guidelines, all she's talking about is what the guidelines are, explaining what they are, and then her opinion is that this particular interviewer failed to comply with some of them in certain points of her testimony. But we don't need to get, unless the state of Wisconsin is challenging their own guidelines as being somehow not scientifically valid, then I don't know why they're delving into all the studies and support those guidelines. So, and certainly not a valid where the issue is simply, is the science valid? Has it been approved, generally accepted? It would disqualify as you so that's why I think it's not necessary to turn over all of these studies at this point. For instance, the state's expert, Liz Gillardi, is a trainer in these guidelines. Is she supposed to turn over every training material she's ever used, all the studies that support those training material? No, I was challenging the validity of, scientific validity of the guidelines then yes, but unless council is saying that's what you're doing here today, then I don't think all these underlying studies are necessary or relevant for purposes of this case.
Judge, a Daubert hearing is to see if the science is generally accepted and if this witness applied it correctly. Counsel's asking you for me to do that without giving me the science she relies on. That defies logic on what a Daubert hearing is. In addition, her opinion is not that Wisconsin guidelines were not followed. That's not all that it is. She talks about misattribution and impoverished disclosure, negative indoctrination. If this is a hearing about the science, give me the science.
Yeah, Your Honor, this is a hearing about the guidelines, what the guidelines are, whether a jury can understand them or whether there's a need for expert assistance to understand what these guidelines are and how they're used. And, you know, that's all their opinions are. All of the, you know, source misattribution and all of that stuff is part of the Wisconsin guidelines. It's not new science.
All right, well, let's do this. Why don't we continue with the testimony? This is sort of a curveball. I'm better at hitting fastballs, but I can adjust and hit a curveball. But I'm going to need to look at exactly what the state's referring to, and why don't we clarify some of that with the doctor, with the witness, and then we can sort it out what does and does not need to be turned over. But and maybe some of this was addressed at the last hearing when the doctor started testifying. If it was, I don't think a transcript's been done, but if a transcript was done, I don't have it in front of me. And so I'm going to need a little more to digest all this. And hopefully Ms. Carson and Mr. Buting can clarify some of this with the witness and for the court, what the doctor's relying on, what she relied on that's maybe an independent study, what she's relied on that's a guideline from the state of Wisconsin, who's drafted or produced the guidelines. So why don't we do that, and then I'll try to figure it out, because I'd like to at least be able to finish the doctor's testimony this morning. I'm assuming we're gonna have somewhere between an hour and a half of cross and redirect. So let's proceed in that fashion, and then after we're done with the testimony, if there's still things that need to be clarified and or potentially produced, Ms. Carson and Mr. Buting can both ably argue their positions, and I will hopefully ably make a decision. So why don't we proceed? Ms. Carson, you ready to continue? Did you start with the cross, or are we picking up?
I started my class, Your Honor, and just for purposes of the record, I sent Mr. Buting an email on March 11th requesting these studies. I heard nothing. I sent him another email on April 13th again saying I didn't request them. He responded to me at 6:15 last night.
I cannot hear.
Doctor, can you hear me?
I can hear you perfectly clear.
All right, I'm gonna ask the lawyers again, one at a time, to not interrupt, because that causes static and problems with our supposedly perfect Zoom audio-visual accommodations. And I'll just let the state go first. I'll turn up the state's mic, and I know Ms. Carson is capable of being almost as loud as me, so I'm gonna ask her to do that. Go ahead.
Can you hear me now, Doctor?
I didn't hear that.
Hang on a second, I'm gonna have my clerk try to see what's going on. Hang on one second, doctor.
Yes. It is.
All right, I don't think my reporter has to take this all down, so just for a second, off the record, Ms. Carson, you want to try again?
Good morning, doctor. Can you hear me?
Bad.
I can see her.
Right, off the record for a minute. Doctor, we're trying to work out the situation. Again, you said you can hear me, correct?
Perfectly clear.
Can you hear me?
No,
And I'll put this on the record in a minute, but just so the lawyers are aware, I've turned up the plaintiff's audio and the defense audio basically as high as it goes.
You want to maybe have her sign out and sign back in? Zoom is weird.
That's a good idea. Why don't we try that? Doctor, can you do us a favor? Can you just log off and then log in again? And sometimes that makes it better. We can at least try that. Everybody give me 1 minute.